Good morning, Ms. Dixon. Ma'am, you're charged with driving while your license is suspended. You're facing up to 6 months in jail.
Whoa! Judge coming in hot. You can feel the tension already. This is that classic courtroom control moment where the judge reminds everyone who's really in charge. But watch. How the defendant reacts here will set the tone for everything that follows.
Jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one.
Yes, Your Honor. On February 24th, 2024, at approximately 11:27 a.m., the officer did a license plate check on a vehicle that was shown to be registered.
So what we're seeing here is a motion to adjudicate guilt. That means the defendant was on deferred probation, basically a second chance, but failed to report multiple times. In Texas, that's a major deal. If the judge grants this motion, probation's gone, and prison time's back on the table.
To have active Class B warrants out of Montgomery County for driving while license invalid, and 6 Class C warrants from Humboldt Police Department. The registered owner was shown to be a Black female, and that female was seen driving the vehicle through the
10 years. Let that sink in. This isn't just a warning. It's a real threat. The judge is making sure she fully understands that her next words could literally decide whether she walks out of court or gets cuffed.
lowered driver's side window, giving the officer reason to believe that the registered owner was currently driving that vehicle at the time. A traffic stop was initiated. The officer made contact with the defendant, who was identified by her Texas driver's license. The officer ran the defendant's information and showed that her license was ineligible and that she did not have any confirmed insurance. The Montgomery County Sheriff's Office and Humboldt PD confirmed the warrants.
Okay, can you run her license now?
Yes, Your Honor. It is not eligible right
And
now.
Ms. Dixon, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to drive. I do not care what's going on in your life. If you do not have a Texas driver license and liability insurance in your name, you are not allowed to drive. If I find that you do, I will.
This part hits hard. You can hear the pain. She's been through abuse, addiction, fear. It's a reminder that many probation violations aren't about defiance. They're about survival. But will the judge see it that way? That's the real question.
Revoke your bond, put you in jail. Do you understand?
I have one question.
Stop. This is not the time for that. If you need, I can provide you a lawyer today, but this isn't where you just get to start asking questions. It's number one. Number two, this is a court. When you come to court, please dress appropriately, okay? So I'll have you go fill out an application with Miranda. I'm going to have you sign a receipt with Victoria. I'll have you take a seat in the jury box while we get your bond conditions, and then we'll have you speak to the lawyer here in a minute, too. Please. How's Jen? Really? It's good? Fun?
No, it's really not, but I'm blessed to be alive.
Well, that's a good attitude to have. That really is, because it could be a lot worse. You could always be 6 feet under, right?
Right.
Your lawyer is asking me to set you a bond, but I'm really concerned. This case is very old, and you've been out literally, she's been on the lam for 10 years, Dave?
Well, the warrant was on November 9, 2015 for this one, Judge. But the surrender for the judgment roll was on, well, actually, the enrollment date was February 16th, but the surrender notice to file was April 2020. So I don't know what kind of efforts they went, but the actual forfeiture date was in 2015.
Do you know that do they really want, are they going to come?
I mean, that's, like with the other ones, I can only confirm the initial teletype confirming that the warrant is valid and they do still want her.
We've tried to reach out to, I'm sorry, Mr. Kim has tried to reach out to the demanding jurisdiction to see how serious of a case is it? Are they really going to come back? But he's been unable to reach anyone. And I mean, it's only been, 30, 45 minutes. So, your lawyer's asking me to set you a bond. Because of the nature of the case, the type of case it is, and because of the age of the case, you're asking for.
Your Honor, the state's asking for $10,000 because it is a possession of controlled substance with intent for oxycodone, and the fact that it's been in forfeiture status since 2015. This isn't one where it's a 2B warrant. It's one where she appeared in front of a judge, stated she would return, and then she didn't do that.
You want
$1,500, Judge. My client has expressed to me that she is a college student.
Being missing on probation is one of the worst things you can do. No contact means no accountability. At this point, the judge isn't just skeptical. She's losing patience. And that's dangerous for any defendant.
She has expressed to me that she only works for, because she's in school, Uber and DoorDash. She has expressed to me that she has an attorney that is working because she doesn't want this behind her. She can't have this when she graduates in May, if I'm not mistaken. I have explained to her the ramifications if this court was to give her the bond, that she has to either, that attorney either has to get her a date set there or she has to go turn herself in within the 14 days. She does not have any other criminal history or connection or contacts with police that were dismissed or otherwise, except for this one case from 2015.
You know, the thing is that I have to set your bond sufficiently high so that you understand that we mean business. I'm not going to play this game with you again. If I set you a bond, it's only going to be one time. I won't do it again. You need to understand that there are serious consequences with the actions that you take now. I'm going to set you a bond. I'll set your bond at 5,000. And if and when you make bond, we give you 2 weeks from the date of your release to go turn yourself in to that jurisdiction where you're wanted from. Mr. Kim, where is it?
It's in Mississippi, Harrison County, Judge.
Go.
So you have to go turn yourself in. If you fail to do that, I will revoke this bond. I'm going to set it at 0. I will issue a nationwide warrant for your arrest. Obviously, I mean, you can't run forever, right? We're going to get you again. And this time I will physically hold you until Louisiana comes and gets you. Do you understand?
I do, Your Honor.
Okay.
So just knowing that, he has made the bond for $5,000, is that something that you can, or you or your family is able to post? Because if not,
5,000 cash?
it's 5,000.
Oh, no, I have a deaf baby. I'm a single parent.
And there it is. 30, the court expects full accountability. The judge's message is clear. This isn't about age. It's about choices. What do you think, though? Should someone with this background get one more chance? Or is the judge right to lock it down?
My husband died 3.5 years ago. I'm on a fixed income. That's why I do DoorDash, and that's why I do Uber on the side, just to help,
So I said that to say that the waiver, if he sets the bond, then the waiver goes away. They don't come and get you. You don't get to have the bond and wait for them at the same time and see which one happens first. So if you're not going to be able to pay the money, then you can, the option is to leave the waiver that you have in place that you signed on, I think 2/27, and then let them see if they're going to come get you or not. But your time, you don't lose the time that you've already been in custody.
So when you buy, I'm confused, when you behind,
What did she waive?
Right off the bat, 227?
So you have 1, 2, 3, 4, 5, 6 days credit. We give them 14 days to come get you. If they don't come get you within the 14 days, we release you. They file a dismissal, I sign it, and then they let you go. If that happens, the warrant will always remain active. And that warrant will always remain active until you physically go back or somehow go back to Louisiana and take care of it. That said, if you want to make this bond, you have to withdraw that waiver that you have, and then you lose those 6 days. So if you withdraw it and you don't make the bond, you lose all that time, and you basically it's told until you re-waive or you make that bond.
I only say this because of the age of the case and the fact that I didn't know she had counsel in Mississippi. It's very, very rare, but I have been seeing it happen here and there, is if local counsel there can get a new setting date. Like I said, it's incredibly rare. I can count on one hand the amount of times it's happened.
What do you mean, get a new setting date?
So even if they don't appear with sufficient evidence from our sheriff's office that she's in our custody and her persons is here, and for a variety of factors, I can't speak to Mississippi because I'm not licensed there and I don't work there, is whatever sufficient factors they have to set a new date for her to self-surrender versus outside of the fugitive, they will recall the warrant. So like I said, it's incredibly, incredibly rare, but only because of the age of the warrant and the fact that she has counsel there.
Well, but we don't know that.
Well, but I'm saying if the information for that counsel can be sent to.
I mean, I'm not going to give you a PR bond. This case is 10 years old. You've been I need you to understand that we mean business. I'm not here to play games. And so that's why we have to set it sufficiently high so that you realize that you have to have skin in the game so that we know that you're going to go back. I'll let you guys talk about it. I don't want you to make a decision here in front of everybody. So you guys talk about it. You know, I'm not stuck on the 5,000. I go back down a little bit, but it's not going to be much, you know, but
I'll stand down. Thank you, Judge.
so, yeah. So
Yes, sir.
I'll let you guys go talk.
Okay.
I don't want you to say something here that you might invariably regret because it's in front of everyone, you know? Okay, please.
Thank you, Judge.
Thank you,
I'll
Judge.
go down some, you know, but a reasonable amount. All right. Mr. Lumumba, you are charged with 2 counts of driving while intoxicated. You've worked out an agreement. They're going to dismiss one in exchange for your plea on the other one. Pleading on 089. This one is, you know, they're all both 08. The agreement that you have is 180 days in jail to be probated for 15 months. As part of the agreement, you will do a DWI education class. You will do 3 victim impact panels, substance abuse treatment. You will also do what's called a TRAS. The TRAS is an evaluation to see what other conditions you may need. They will probably, because the fact that you have 2 open DWIs, they will probably add other conditions. It may be supportive outpatient treatment. It may be intensive outpatient treatment. I don't know. It may be inpatient. I have no idea. You must fulfill whatever other conditions they assess on you. No drugs, no alcohol, a guardian interlock, 25 hours of community service. Is this how you understand the agreement?
Yes, sir.
You need to understand that one of these will go on your record. The other one is going to be dismissed. But because of the fact that you have at least one of these going on your record, officers will always see this forever. It doesn't matter where you are, whether you're here, whether you're in Maryland, whether you're Alaska. And if you get pulled over, an officer, first thing they do is they run your license. They're going to see DWI, DWI. If they come up to your car and they smell alcohol on you, what do you think they're going to do?
Pull me out
Not just pull you out.
and breathalyze.
And what?
Arrest me.
Probably. I don't know for sure. But chances are they're going to see DWI, DWI. If they come up to you, they smell alcohol, it's probably not going to go well for you. So if I were you, even if you've had a sip of alcohol, don't get into a car.